Hey, we are live.
All right, we're reconvening our morning meeting and switching gears to H 230 with the Fish and Wildlife Department coming in on a couple of particular sections. Welcome.
Morning. For the record, my name is Hannah Smith. I'm the general counsel with the Department of Fish and Wildlife. And I'm joined by Colonel Justin Stedman of the Warden Service, and we're walking through sections 4 and 5 of H 230, which the committee reviewed, I think it was about 2 weeks ago now. And this relates specifically to the law enforcement and the civil versus criminal penalty track. And the language that was introduced in the bill created under, it's 10 VSA 4572. So the language begins on page 5 of H 230. 4572 currently exists. It lays out a number of fish and wildlife violations that the legislature determined should be treated as minor violations. So they would, it be a civil penalty would be imposed rather than a criminal penalty. And currently there are 7 violations listed in that section. And that's the full scope of things that the legislature has determined should be treated as civil. And the language that the department introduced would create an 8th category of civil fines. And those are essentially all other fish and wildlife violations, except for the big game offenses that have jail time associated with them, that meet certain conditions. And the one of the documents that I shared with the committee yesterday includes some proposed revisions to the language, in part to address concerns raised by both your counsel, Michael O'Grady, and Judge Stoney when he was in here talking about enforcement discretion, essentially, and avoiding any, either sort of the implication that there might be inappropriate discretion exercised or too much discretion that would actually make it difficult for a warden to do their job in the field. So the new language that we propose, this begins on page 6 of H 230. And I highlighted it in the copy that I sent yesterday. So it would essentially, so the new subsection 8 would read, except for big game offenses and under revocation offenses, any fish and wildlife violation as defined by 10 VSA 4551 and not otherwise listed in this section shall be charged as a minor violation, provided that, and then there are 4 conditions, and E should be D, I apologize. But provided that the offender has no prior history of fish and wildlife violations, there's no need to seize evidence in order to further investigate the violation. There's no need for a criminal warrant to further investigate the violation, and there's no possibility of forfeiture. So this shifts the analysis slightly away from full discretion to actually the policy approach from the Warden Service would be to treat all violations that don't have associated jail time as minor unless these conditions are met.
You help me understand under revocation offenses.
So it's very similar, separate system altogether, but just like if you lose your driver's license by accumulating enough points, the same is true of your hunting, fishing, and trapping license. If you accumulate enough points, you lose your license and are under revocation. And so this would apply to people who have received enough points to have lost their license, who then go out and continue to hunt, fish, or fowl.
They would be then subject to criminal.
Correct. Yes,
Thank you. That might be able to be cleared up a little, but that's what you call it, under revocation offenses.
yes, ma'am. And I believe that language is taken right from 4280, which is the section that covers that.
And just to note for everyone that this is an and, so you'd have to meet all of these.
And I actually think that in rereading this, it should be an or.
Big and or difference. Yeah.
If one of these conditions is met,
Or
Right, it should be.
It
should be or.
Yes,
Okay.
Yeah.
it should be or.
Yep.
Thank you.
And yeah, this would, yeah.
If one of them is met, they need to go criminal.
Yes.
That's what the intent, and that's accurate.
Okay.
Yeah.
Thank you.
Yep. Representative Austin.
Yeah, can you just, because I'm not a hunter, there's no possibility of forfeiture. What does that mean?
Yes, ma'am. So there are certain violations where, for the one that's most commonly known, if you were to attempt to take a deer at night and you were to use the headlights of your truck to do it and you were caught, there is a process by which the warden service and the state, it's the state can compel forfeiture of your vehicle. And
Oh.
we take possession of it and then sell it.
Okay,
And that applies to any implement of the crime when taken under certain circumstances. So
so does this mean someone wouldn't have a car or some truck that you can take? There's no possibility of forfeiture?
So what this is saying is that if you commit a crime where there is the possibility of forfeiture, this process would not apply. Because we would never go civilly through that process.
I see.
That's an entirely criminal process that requires, it's comes after a conviction.
Yeah.
In a criminal court, and it's a separate process that goes through the criminal courts.
Okay, thank you.
So a few of us are reconsidering the and or and thinking actually it's an and. They're meant to have all of those characteristics. Yes,
Should be considered minor. All of those have to.
yeah,
Just the way it's
to
written.
meet the intent.
Shall be charged as minor violation, provided that all these things are true.
Right, so if one of those is not true, then yes, so it is.
I think it
If
is.
any one of them is not true, then it's not minor.
Correct.
Right. That's the intent and that's the way.
Yeah.
Oh, yeah, I love the English language.
I was, yeah, so I did that right.
You did
I
it right.
was
Yes, you did.
wondering how I made
Yeah.
such a glaring error, but yeah, that's correct.
Okay,
Did you notice how I was gonna take the blame and I'm giving you all the credit?
No, no, that's correct. They will provided that all of the following, are met. Yeah.
great. Yeah, Representative Zachary.
Yeah, just before we move on from this, these four conditions now, you feel pretty strongly that the amount of discretion involved in ascertaining the relevance of each one of them is narrow enough that it feels much more comfortable than before.
Absolutely. So ironically, this language I had already written to put into policy with the way the previous law was written, because one of the issues we face right now, and Judge Zone I don't remember if he sort of hit on this or not, but one of the issues we run into right now is that the 14 counties handle these violations very differently. And you might get a ticket for fishing, for taking too many fish in Chittenden County, and it's just summarily dismissed because they have no capacity to deal with it. Whereas you may get the ticket for the exact same offense up in the Northeast Kingdom, and they're going to take it to trial because they have a very strong view in some of those counties on how to deal with these things. And while we're very appreciative of that approach, it causes issues when one person is getting hammered and another person is getting nothing. And so we want to treat people as least punitive as possible. Like that's the goal. That's what we're trying to accomplish. And so I do think this language gets to it. Yes.
No, I understand that part of it. I'm just, because we had heard, this revision from the previous version is because of the amount of discretion that was perceived, that it was too broad before. And this does obviously narrow the discretion. I'm just trying to get a sense from you that these four criteria, like in the field, like that they really are like pretty clear, like
Absolutely.
that there's not really a lot of wiggle room in terms of whether you're meeting them or not.
So
Yes.
let's go through them. So the offender has no prior history. Is a warning a prior history?
So that is technically a prior history in it doesn't, and I should also clarify that, so we have nationally, environmental law enforcement has a detection rate somewhere around 10 to 12%. So if someone has run into us where we have issued paperwork, it's a fairly small percentage of offenders actually ever there's more than 32, there's 42 of us in total, but there are 32 wardens for the entire state of Vermont who do this enforcement work. So for them to be in the place where you are at the time you're violating the law, you're either doing it an awful lot or you're just not very lucky. One of those two things. It's really how it boils down. So in our world, a warning is fairly important because we don't encounter all the people that are doing this.
Mm.
So it would certainly, in our book, count. However, if the committee feels that that you would like to see those maybe identified differently, I'm certainly willing to have, happy to have that discussion, but from our perspective, yes.
Okay, and then when is there a need to seize evidence?
So I'm glad you asked. So I had two pictures that I just wanted to pass around. Is that okay?
Mhm.
So if you look at the first one for a second, and then you look at the second one, it should become very clear. But there are many people who go through great lengths to hide what they're doing. And
That's pretty ingenious, though.
it's very ingenious. Wardens oftentimes, because of how we operate, we spend a lot of time looking. We spend a lot of time watching before we ever act, because without some ability to know what's happening, it's very easy to spin any number of stories. And so the need to seize evidence becomes relatively apparent. I tell this story. I watched a gentleman fishing who had a stringer hanging off his waders. And I'd watch him. He'd catch a small enough fish and drop them in his waders. And so when I went down to check his license, he's like, yeah, I got my fish. And so we go through the whole thing. I'm like, what about the ones in your waders? And you should have just, his whole face just. However, if he had been like, I don't know what you're talking about, if there is no ability to actually go to the criminal system and be like, I'm seizing your waders so that I can get a warrant to look inside of them. We have no ability to enforce what we know has happened. And so in this particular case, the warden's watching the guy catch all these fish. Then he goes over to check his license. The guy's like, yeah, I got 3 fish. And the warden's like, I watched you catch 12. And the guy's like, I don't know what you're talking about. If we don't have a capacity to say, all right, I'm going to seize your boat, I'm going to apply for a search warrant, I'm going to look in all the parts and pieces of it, we're never going to be able to prove that they caught more than that number of fish.
So help us imagine, how does that unfold? Does that warden seize the boat right there, or does he have to go back to the judge?
So what would happen is we would freeze the scene, basically, is how we do. Obviously, if it's on the water, we'd come back to shore. We're not going to seize it.
Those waders are gonna start smelling it.
Yeah, absolutely. And we would do that we would not wait for, we'd get a hold of the on-call judge to apply for a warrant. We wouldn't wait for
I
a
see.
business hours type thing, because you're right. It's also, this evidence is not like, it's not stable, right? It deteriorates very rapidly. And
I
so-
see, it happened quickly.
Absolutely. Yeah, absolutely.
Representative Tagliavini.
So let me get this straight. You swear an oath to uphold the law, but you witnessed someone dumping the evidence into their waders, but you have to get a warrant. You just can't issue the ticket right there because you witnessed it?
So what we run into is basically that he said or she said, right? I watched you do this. I didn't do it, Your Honor. And it just literally becomes my word versus yours. And so when we have the physical evidence, it is irrefutable. And quite frankly, oftentimes you will have 2 people in a boat. Bob didn't take that many fish. I was sitting right there with him. He only caught 3 fish. I saw it. And then it's 2 words versus 1. And we've tried things with recording devices and things of that nature, but a lot of this stuff is happening at distances where that doesn't work. It actually doesn't help because you can't see what's happening in videos and things. It's like, well, I don't see him catching any fish. It's like, you're 250 yards away. But so that's the issue, is people aren't truthful. And so you need the evidence to prove the case in court.
Are you able to take a picture of that person putting the fish in his wader?
Or
We try again, but oftentimes, like I said, some of the stuff we're talking using spotting scopes.
No, I just said legally.
Oh, yeah, and oftentimes, so there's another prime example. So we pull up the boat. Hey, how many fish you got? Well, I got too many. If they're still alive, we'll photograph them and let them go. We won't seize them and kill them if we don't have to.
And so the guy who fesses up and says, yeah, I took too many right away.
Civil ticket, here's your day, go on your way, have a nice day.
Yeah, okay, great.
And again, that's back to, I recognize that when someone they wear a different outfit than this, but when we show up, oftentimes the first reaction is like, I didn't do it.
Yeah.
It's kind of just how people react. It's not necessarily, and then oftentimes they will come in later and be like, I'm sorry, I lied, man. I was scared, or I was whatever. And so this is an attempt to recognize that as well, that if we don't have to seize the evidence, here's your civil ticket, go on your way.
It's in a second.
And you're in one of these situations and there's a determination to seize evidence or not. Like that determination is most of the time very clear cut. Like there's not, that's
Yes, and so where, again, where it would be, where the need would be to seize evidence is typically in the situation again where it's usually a couple of people and it's an immediate, no, they didn't. I've been sitting here the whole time. They didn't do that. It's like, yes, they did. No, you don't know what you're talking about. And I mean, people throw fishing rods over the boat. I wasn't fishing. Like, it's right down there. I can see it, you know? So it's, again, it's a typically people don't know we're about to show up, really. And they're often they're a little happy place. And all of a sudden, someone with a badge and gun is like, and they're like, and they do some weird things.
So help us understand the difference between B and C. There's no need to seize evidence. There's no need for a criminal warrant.
Sure. So the other example, so sometimes there is in the case of some of our restrictions. So for example, there's size limits on fish. So an argument over whether or not a fish meets the right length requirement is something where we might seize the evidence to prove this fish was actually 9.5 inches, not 10 inches. And I know the half-inch thing sounds like, but there are plenty of people who will try and skirt the line and they'll squeeze the fish or they'll step on the fish to try and make it long enough. And so there are times where that would be a reason to seize the evidence so that we can prove unequivocally, especially not all, if you don't have a ruler or something where you can take a measurement photograph where you'd want to seize the evidence, as opposed to that battery box. I don't have any fish in this boat. Think you do. And I'm going to ask a judge to give me permission to search your boat because I've been watching it and I think you do. And so, and the other thing is it might not be granted, right? The judge could be like, yeah, no, sorry, we're not going to grant you the warrant. And then it's have a nice day. Here's your boat.
Why would the judge not grant the warrant?
They don't find probable. I mean, I'm hazarding a guess now. I don't think I ever had a warrant that wasn't granted, but I mean, we have had warrants denied and the judge either doesn't find probable cause or exercises judicial discretion.
Representative Morris, do you have a question?
Oh,
I would,
All right, so then.
reading my pen.
There's no possibility of forfeiture.
that goes back to, that just simply excludes all of the violations by which which would potentially have their vehicle or gun or anything else forfeited. And that's a certain section of laws that it just excludes all of those by definition.
And are those generally the big game violations?
Generally, but not all.
Like what's not?
So 4705, shooting from a motor vehicle or loaded long gun in a motor vehicle. I believe it's one of those sections, and I'm gonna get it wrong, has the possibility of forfeiture in it, and I can't remember which one. So that section of 4705 would not apply, but it is not a big game offense. That's one that readily comes to mind.
And it is a criminal proceeding. It requires a criminal proceeding because the equipment could be seized, but in order for it to be formally forfeited, where the person no longer has possession or owns it, they have to go through a criminal process for that to be ordered.
And I don't want to give you a percentage, but we do not seek forfeiture on every case where forfeiture is applicable. This would still exclude them. They would not be part of this, but I don't want y'all to think that like we're seizing 100 cars and 200 rifles a year. I mean, I think we took 2 cars or 1 car last year. So it's not, we don't.
You don't take it lightly.
Correct. Yes.
Representative.
I just had a question back on A. I just want to make sure that the definition of the word violations does include warning.
So in my mind, it would, however, again, I'm certainly, if the committee doesn't want to include that, we can certainly have a discussion about.
I just want to make sure I understand the technical.
In my mind, it did, yes,
And
because
that was the department's intention. If it needs clarification, we could say including a warning issue.
Probably it should say that. Yeah, clarity.
and I apologize, I just didn't know if you're asking because you didn't want it to include that, or if it was just a
I wanted to know
question.
what
So,
the
yeah,
technical definition
yes,
is. Is
so
that
we can
word
certainly
defined
change that.
word somewhere else in the statute that clearly includes warning?
Gotcha.
Just want to make sure I understand.
The statutory definition does not include warning.
Does not.
So we would
So
want
we
to include.
Want to include warnings, we need to clarify.
Yeah.
If that's the intent. So we need to discuss that. Representative Pritchard.
Yeah, I mean, I don't think a warning is a violation.
Yeah,
I
I
don't.
wonder too. Representative Tagliamia.
The issue of warning to me is there a warning on the record? How far do the records go back? If there was a warning 5 years ago, is that going to be change things?
So our point system is a 5-year timeframe. That's how long of basically the points stay on your record. So unofficially, there's no set statutory or regulatory requirement, but that's sort of the unofficial timeframe by which the warden service operates. If it's past 5 years, then we don't get too excited about it. And if it's within the 5 years, that's when we typically, so where that applies, and what I should say is one of the biggest ones is that failure to carry your license prior to all the technology. You used to get a warning and you had 7 days to produce a copy of it. If you had had a warning for that in the previous 5 years, the next time it happened, we typically would write a ticket. That's where that sort of unofficial process had sort of played out as a matter of operation.
But does the warning ever expire or go off your record?
So it's a great question. So it's in the digital world. Ironically, the state switched, which I don't know if you have been, we switched from Spillman to Valcor in 2022. And so most of our records prior to 2022, the field force doesn't have access to anymore. There's only a certain set of people. So the answer is no, but for all practical purposes, the current system we're in only goes, or not 2022, I'm sorry, 2021, only goes back to 2021.
So, but if you had a points violation, they get erased.
So no, so the points come off after 5 years, the points come off of your record and you are able to do what is necessary, either the remedial hunter ethics or just go by your license. But the record of that remains in the database that it for perpetuity, I suppose.
Give us an example of, no, you gave us one example of when people get a warning, the most common being when you don't have your license, but what other kind of, that's it. So that's enforcement discretion right there already happening in the field.
Correct. That's a civil violation too. That again, there's any number of things. I know there are a lot of people who write warnings for life jackets, just because they don't want to write, on a kayak. And I was in the Coast Guard prior to this. I was at several drownings where life jackets would have made a difference. I didn't write warnings. I wrote tickets because I felt strongly about it. But there are certainly any number of violations. Any of our violations could have a warning issue. They could be issued for any one of them.
But only the civil.
No,
No.
they could be issued for the criminal.
Huh. So what do members think about this warning versus, is a warning a violation worthy of?
I don't think it is.
No, I don't.
Can you say why, Chris, or Representative Pritchard?
Well, if it was a violation, you'd be issued a ticket. And I think in a lot of cases, and maybe the colonel can correct me if I'm wrong, but I think a lot of these, in some of these cases on these warnings, they're brought to the department's attention by people. They're not swept under the rug. They're by honest people that made a mistake.
Mm.
And I don't think, if they made a mistake, there should be a violation. They should pay a penalty. But I think it's important that I just think there's a lot of people out there that make honest mistakes that would never get caught ever, but they bring it to the attention of the department.
And so, wait, so you just said, I heard two different things. Do you think someone who makes mistakes, brings it to the department, should pay and?
No,
Yeah.
what I'm saying is that they make a mistake. It would have never been found out. They made an ethical decision to approach the department. Hey, I made this mistake, and they're issued a warning. And I think some of those warnings are based on that. And so I think I think on those types of things that they shouldn't be penalized for that. It's not a violation. And that's a judgment call on the wardens. Does it vary from warden to warden? I'm sure it does, but I just don't think that it should be part of this.
Okay.
And are points assessed on a warning?
And if I may, this is so thank you so much for bringing it. This is the impetus behind what we're asking for, because for a warning to be written, all of the elements of the crime have to be present. A warning cannot be issued because I think you did something wrong. A warning can only be issued if you in fact did something wrong and I, as the officer, determine that you don't deserve a ticket. That's the only way a warning gets issued. And a lot of people, the general public, feel like, well, I got a warning, I didn't do anything wrong. And that's the issue that we run into. Our choice is hammer or nothing. And that's what this is an attempt to create, is a different tool other than a hammer to say, hey, you did in fact do something wrong. You don't deserve a criminal record for the rest of your life, but there is a penalty, there is a fine, there are points, and here's your ticket. And that what you just said is what we hear over and over again from the general. I had a warning, I didn't do anything wrong. You did. You did exactly what this says you did, and we could prove it. The warden chose to write you a warning. And so that's exactly what we're trying to get at. So how we deal with this is certainly we can discuss, but I just want to point that out, that that's where this is part of where this is born from, is the idea that people think, well, I don't have to pay a fine, so I didn't do anything wrong.
Yeah, right. Representative Tagliavia.
I think to your point, I think the warning is a good PR move. It gives you a chance to explain to someone maybe something that they didn't quite understand, and they don't walk away feeling like you said, they got an education. 90% of the time, they're not going to do it again, and a warning is enough. And they're going to talk to their friends about it.
So Representative Sakowitz, the North, and then I want to make sure we have time for the rest of your testimony. There's other stuff we're going to look at with.
Yeah, I would just say that given what the intention is behind this language that you've brought to us and what you've just told us about the history of the likelihood of even getting a warning, and what that means, I would be comfortable with having another line in here which says that it also that you also have to have no prior history of a fish and wildlife warning, and perhaps within the last 5 years, since that seems to be what your practice already it is, and we could just have it in statute as very clear what.
Absolutely fine.
We
I
did.
think it's a great idea. Certainly.
That's a different direction. We'll need to talk about that. Representative Nor.
I just wanted to make sure I understood again for technical definition purposes. What we're creating here is a minor violations. Is that the in-between hammer, in between nothing and hammer? We're talking about the
Yes.
minor is the in-between thing.
Correct.
Is minor violation different from a warning?
Yes, so a warning has no points and no penalty. You pay no fine and you get no points. A minor violation carries points. Typically it's, oh, sorry, go ahead.
So the only thing that a warning does then, no points, no violation, but it does show up on your record.
Correct.
So that you could find out within 5 years later that you did get a warning. Right, so the only impact of a warning is that it's on your record as a warning. That's correct. No fee, no other consequences.
And just we run about 75% warning, 25% pay ticket or citation or civil ticket. Like traditionally, I mean, that's the way it's always been. We write a lot more warnings than tickets. And I think that's indicative of the fact that we're not trying to hammer people. We're trying to be reasonable. It's just we have very few options.
That's real.
One more. Representative.
So, and this is important, and you can attest to this, this is when I do my hunter safety classes, which you have been part of over the years, when we get to the part of the wardens, one of the things that we talk about and you talk about and the other wardens talk about is if you do something wrong, you need to let us know. You need to come. And I think it's important to really, as part of that message, is that doesn't mean you're going to get a baseball bat over the head. What we're trying to promote is ethics and taking responsibility and doing the right thing. So I think as part of that message, as it ties into this, I think it's important because it's a department's message. It's a message we give kids and adults in our hunter safety class. Do the right thing.
Okay, so you've provided us also 2 lists.
And both of the other documents tie directly into this proposal. We did provide a spreadsheet with a complete list of fish and wildlife violations. And it's 130 odd separate violations. And then the third document,
Say 130.
roughly.
I forget the.
I don't remember. I don't have this. It's those, yeah, and those are all your criminal tickets. Those are all, like I said,
Right.
those are criminal offenses, but are written as a ticket that people can just pay. And end up.
And the list, the list that we provided does not include the big game violations or the
Mine.
minor, what are currently defined as minor violations under 4572. So it's the complete list of those criminal tickets that the department issues, which under this proposed language, we would be converting some or all potentially to a civil ticket.
Is there a way for us to know which one?
Well,
Here, under your other list.
yes, so I think if the committee were to adopt some version of the highlighted language that we shared, it would essentially be all of them. It would be the warden's discretion,
Okay.
and they would issue a civil ticket unless provided that the four conditions were met. The third document that we provided in response to some questions we got during the last testimony was what could potentially be called a civil violation without any associated conditions? Like what are the violations right now that are criminal tickets, but almost never require the collection of evidence, forfeiture, a warrant? And so the colonel worked with the warden service to develop a short list. If the committee were to, want to actually insert all of those individual violations into 4572 as an alternative to giving the wardens broad discretion.
Is that the one with the fine numbers next to it? Which one are we talking about?
Yes, yep, it's a one, or I guess it's one and one line on the second page.
Starts with Title 10 list of Fish and Wildlife criminal offenses.
But it doesn't make sense to me because these have fines associated with them.
So the civil ticket would have a fine associated with it as well.
But it has points also.
That's correct, yeah.
What I did, ma'am, is these are literally taken right off of that criminal list. So I just took them with what the points and the fine were, just so you could see what they currently are as a criminal offense, just so.
But then you're saying these should all they would all fall under the civil, under the language you've given us.
So
They could potentially. So when we were talking about, when we presented the language the first time, I think a concern raised by the committee was that just giving the warden's discretion to decide what's criminal and what's civil might be problematic. And so this list is an alternative to that, where the committee could actually adopt into statute a list of things that explicitly will be treated as civil violations. The points and the fines, as the colonel mentioned, those are just pulled right now from the criminal points and fines. In order for this to be adopted under the civil system, the Judicial Bureau would actually have to evaluate the violation and assign a penalty to it, to a civil ticket. It would be a process that the Judicial Bureau would have to undertake. The Judicial Bureau could take the fines that are assigned to the criminal tickets and adopt them exactly as they are under the civil tickets. That's what is provided here.
So in other sections of statute, I believe we do, as a legislature, list the violations that are civil and criminal. Right? So the Department of Motor Vehicles comes to mind, but probably other places too.
you did it, it's been done in Title 10. There's the list of 6 civil offenses that are minor right now.
Dipped our toes in it. Given the list of violations, potentially.
If I may just add some clarity, ma'am, if the committee decides to accept the language that is currently highlighted in section 8, this becomes irrelevant.
I get it. Yeah.
If the committee doesn't like that language and still wants to move something civil, this list is the things that we identified that you could move civilly without impacting our ability to do our work.
Oh, there's a lot of interesting things on here. Representative Sakowitz.
So if we were to adopt the list instead of what the revisions are in the bill, then people who engage in those violations would be civil no matter how many times. Whereas if we kept the bill the way you've proposed, if they did it more than once and were caught, then it would become criminal. So it's a significant difference
Yes, sir.
in those two.
Yeah, Representative Chapin?
Sorry, it's a sort of discussion, but
we could say if this happens more than once, then it's criminal. So
Yes.
we can address that. I'm not sure that that's, it has to be a difference.
Right, yeah.
I don't want to complicate things anymore, but the last part of this
Yeah.
was the other thing. So if the committee is uncomfortable with the idea of moving all 100 and however many it was, we had the idea of identifying some of the ones that we think that would be of the most benefit to Vermonters and of people who visit, the ones that are most easily violated without intending to. And so the idea was there's actually one on the back. I don't know if it goes on the back of yours, but I think there's eight. 6 and 8. 8 of these, that if the committee wanted to, and I don't know if it would be via some sort of a sunset option or something, we could sort of give it a test drive with a very select subset to, you know, say after a year or two, well, there aren't a ton of people complaining and most people are being, you know, it's being generally applied the same way and most people get, it was just an idea that we had to try and provide some options for the committee to look at. And those that we identified are just the ones that are most easily violated by people who may not know what they're doing. So, again, sorry, not trying
How do you take game by other than a gun or bow and arrow?
Well, Gordon, working one night in a college town, watched 2 young men with a blowgun try and shoot deer. They were heavily intoxicated.
Probably suspected,
Was alcohol.
The deer were intoxicated, yes.
probably suspected that they knew that wasn't.
Well, we've had people try and use atlatls. So it's like I believe they're used mainly in Africa. It's a stick with a lever that has a spear that you then throw that launches the spear.
Representative Jacob.
So I'm just, want to keep trying to get at why one or the other. So if we went with the language that you've recommended, would you use a list like this in order to clarify in training or, you
No,
know?
ma'am. This entire list, it would apply to this entire list, and it would say, we would, on our end, we deal with sort of whether or not the judiciary creates separate fines and all that. We deal with all that, but it would be this entire list of offenses, which you have in the Excel spreadsheet. And if you were to violate any one of those and not meet that criteria, you would get a civil ticket or a warning. A warning is still an option, but it allows for the civil ticket to be written.
So I'm sorry, I'm looking at not the spreadsheet, but the list that you provided as an
Yes, ma'am.
alternative.
Yes, ma'am.
So that list, are you saying that may be more limited than if we just go with the language that you recommend today?
Yeah, based on the testimony last time, we weren't sure what the comfort level of the committee was. So we were just trying to come up with some, and I believe the specific request from you, Madam Chair, was what is a list of things that could just be civil and there's no discussion. And that's the first part of this list, is the things that we identified out of that 100 and however
I
many.
understand your process.
Okay.
What I'm trying to get at is which one's more like, are they going to end up with the same result, or would there be some significance in the difference in what results out of one or the other option?
Sure, if you do this list, there's no, in, as just saying, these are now civil, there's no option for a criminal penalty for any of these. It is just a civil offense. And that's how that's how we have now. We have 6 offenses that are just civil, no matter how many times you go fishing. If you don't have your license, well, there are some other things, but those are civil. There's no option for anything else. Or if you put a tree stand on a property without landowner permission, that's a civil ticket. That's the only option. And that would apply to these right here. If you just said, we're not adopting a dual track, these are just civil.
And what you just described as those 6 offenses, is that in statute or is that in policy?
For 40,
The 4572, it's currently in
45,
statute.
72 is in statute.
We should get that list. Further questions, Representative Austin?
Now, is it permitted to use a drone to locate wildlife?
No, ma'am.
So where would that be in? Is that like a criminal?
That is a criminal,
Oh.
yes, that I would have.
It's okay. No, I'm just,
Yep.
yeah.
They are prohibited right now. Ironic you asked that question. We get a lot of questions.
Well, yeah, and then it
Very popular.
makes me want to ask the question about what about live game cameras? Are they like real time is what I mean by live? Are those legal?
They are not technically illegal. Well, they're not technically illegal. I'll leave it at that. There's some nuance that we could discuss, but I don't want to confuse things. So they are not technically illegal. There has been discussion about whether or not they they do actually lend themselves to fair chase. And
Also privacy of other people in the woods.
there was a bill brought up last year to the
Yeah.
Senate.
I think it
Committee.
got across, actually.
It did, but ironically, it excluded game cameras. And concentrated more on drones and like door ring bells and
We
things
had
of
one
that
on game
nature.
cameras and in-house judiciary last.
Did it
time.
pass? Because the person that sponsored the game camera one thinks it passed.
She was the woman from Essex.
She had a constituent who had a
Okay.
swimming hole. That someone had a game camera and would watch her and her children swim.
Oh, yeah, that's creepy.
We might have put it in miscellaneous. We might have put it in miscellaneous.
It was in a miscellaneous bill. I think it passed. Anyway, we should follow up on that.
Be better inner dialogue.
No, that's okay.
It is creepy, and that's why it was brought to our attention.
I know I testified in the Senate committee last year about a bill that originally included game cameras and then it got pulled out of that. And the woman who was there had found game cameras on her property when she went to find her kids or whatever, and she was pretty upset about that. But they were taken out of it, so. In that bill that went through it, it applied to drones, Ring doorbell and some other cameras that were pointed at houses or something. It was a strange.
Tagliavia.
I'm looking at this list and 4786 says game suppers, no permit. Could you clarify that for me?
Sure, so you cannot, no organization can have a game, so it is illegal to sell wild game with a few minor exceptions. And so a game supper permit allows fire departments and Rotary clubs and things of that nature to basically sell wild game, because you have to typically pay to go to those things outside of the regulated time that it is allowed, or in some cases, it's not allowed at all. And so this allows them to do that. The reason that we put it on the list is because if you're the Pollitt Fire Department and I drive by and you've got a game supper and I'm the warden and I know it didn't write you a permit, it's pretty obvious you don't have one. So.
Be asking you for a warning because I had no idea.
You would be surprised. Most of those organizations have been getting them for 100 years. So, yeah.
4%.
Okay,
Hmm.
but if this was promotion or something and there was no transaction of currency, then it wouldn't be a problem?
Like,
Like a game supper, but there was no fee charge, no donation of any kind.
the specific to the game supper, yeah, but there's other issues that I can complicate it if you'd like, but there are various ways to address that scenario
Okay,
on our side of the house.
But do you need a permit is what he's asking? If you're not selling,
If you are
Ticket.
providing
Serving.
fish or game of another to somebody else, you would not be able to do that without some sort of permit. Because you're not allowed to be in possession of fish and game of another. So.
They have a permit for.
wait a minute, you serve your neighbor's venison that you shot?
Again, there's some nuances to that, but I'm trying, yeah. You're fine. I'm trying not to complicate this.
you won't be getting anything in the mail.
So no, you certainly, if you want to give venison to your neighbor, that is not illegal. But what happens is when specifically to a game supper, in that sort of a scenario, they are collecting animals from other people for a prolonged period of time. And so they're in possession of an awful lot of animals, which oftentimes puts them in excess of their possession limits outside of the season, because they're taking roadkills and things of that nature. And so even if you didn't charge a fee, in order to get to where you had enough stuff to serve a meal, you would be in violation of other issues.
Maybe, you could have a potluck that everyone.
Yeah, everybody could bring a potluck, absolutely.
It's
You're
really
beginning of hunting season and everyone brings a dish.
Sure.
Yeah.
And if you're not charging, technically, if you're not charging a fee, then that's where, actually, I don't even know if the game supper says you have to charge a fee. I think it's just a mechanism by which it allows people to
Anyway,
break the law.
I don't want to go down too many rabbit holes, but I, of course, the chair has one. Remote control hunting prohibition.
It's the drone.
But is it only drones? I mean, what is it?
No, there are firearms that operate with cameras.
Macro.
Basically joystick, it's like playing a video game. Except with a real gun.
So can they control it at home?
Yes, ma'am. I mean, that technology has existed in the military for decades.
And are you seeing that technology? Have you seen that in Vermont? being used?
I personally have not, but I do know in other states where I'm friends with, they've seen.
Okay. Further questions on this? Yes. What else do we, I mean, I feel like we digressed enough that we need to circle back to the purpose of your visit today was to bring us proposed language that addressed testimony we heard previously on this topic.
Yes, that's correct. And to clarify, the language that we provided in H 230, the highlighted language, that's the department's preferred approach. I think to Representative Sackwood's point, it allows us to, when somebody is a repeat offender, it allows us to use the way of the criminal justice system to deter that activity. We provided this list of criminal offenses that could be treated as civil as an alternative if the committee wants to sort of look at the efficacy of adding to the explicit violations in 4572.
Yes, that's very helpful summary. And so if we include this language in this bill, the bill will surely go to our Judiciary Committee. So,
Assumes.
yeah, that's another decision point for us. We seem to be working closely with our Judiciary Committee this year, so it's fine. They're taking up a number of bills where there's mutual interest.
And if I may just add, it takes wardens years to get this stuff down. So, this is not trying to be patronizing. I applaud all of you for trying to get a grasp, but this is complicated stuff. I mean, there's a reason wardens are in training for as long as they are. This process is complicated, and it's not, sometimes it defies logic. And so I applaud all of you for trying to wrap your minds around it. And I appreciate the fact that you're asking questions, because it's not as simple as it may seem on the surface. And so that's just with literal heartfelt appreciation, because it's not easy, and we make mistakes all the time.
I mean, yes, and it's impressive. And I guess I am curious how you articulate the list of violations to new wardens, or even how do they manage?
We have the longest training program of any law enforcement agency in the state. They do not even go out on their own until they've been working as a warden for a year. So, and they spend every day, either once they're out of the academy, they spend every day with another warden just working on this stuff for 8 full months. And then when they're out on their own, they work with a neighbor that we identify to help, because it's complicated. Old Colonel told me once it takes 5 years for a warden to be truly effective, to know what they're doing and how they're supposed to do it.
I'm sure.
Same with the legislature.
Yeah.
I'm gonna work on it. I'm gonna use my inner dialogue and just say, okay. No, just kidding. Yeah, I'm sure it's.
Representative Pritchard.
But I get it.
Thanks. A hip violation. So what would a hip violation be? Just if you were migratory
Correct.
running, right?
Correct. Yep.
All right.
And that's, you simply just didn't get your free hip number.
Okay.
Further questions? Representative Morris.
Thank you, Madam Chair. So getting back to the specifics, what is the department's preference? See the language that is highlighted
Yes.
and including warning or not including?
Well, I think that the department is interpreting the offense to include a warning. And so, well, let me take a step back. The definition of a fish and wildlife violation does not include a warning. So the way that the language reads right now, I think that it only includes violations that were actually charged, not warnings that were issued. The intention when we drafted this language was that an offender with a warning on their record that would be included, and a criminal ticket would be issued. Is
Yeah,
that
and I
correct?
think we can add some clarifying language and include Representative Sackowitz's idea of within 5 years, because I think that's at least from my perspective, that's what we unofficially use anyway. So why not codify that?
I see. So add, including a warning within the last 5 years.
Yeah, I was thinking if we said something along the lines of the offender has no prior history of receiving a fish and wildlife, we could even say civil ticket, information, citation, or warning within the past 5 years. I mean, make it very explicit, because again, the idea behind this is not to allow people to use this to punish people more. Like, I want less. You know what I mean? I want the option to treat people with the feather as opposed to the hammer. And so to expressly identify that simply, in my mind, advances that idea.
Representative Moore.
And so if wording the way you just worded it, all of those different types of offenses, different levels of offenses are windowed within just the past 5 years.
Correct.
Any of those offenses, even if they were civil offenses or criminal offenses
Correct.
6 years ago.
And that's how it
count
is.
here.
Correct, yes, and that's how it is in our system now, whether you commit a big game offense or a fishing without a license offense, a civil offense, or, you know, you get the full weight of the criminal, it's a 5-year window.
5 years.
And I think that's indicative, we don't catch we have a low success rate, and it's just a reasonable time frame in my mind.
Just want to make sure that's what you intended
Yes,
to
sir.
apply it to all of those.
Yes, sir.
And assuming that, you know, once Valcor has been actually
Mhm.
in effect for 5 years, wardens in the field have access to that information.
Yes, and we do have, I was trying to answer this specifically, but yes, we do have access to the old information. It's just through certain conduits. Not every warden has access to that information, but that information still exists.
Got
And we
it.
still maintain records. But the average warden can't go look at something that happened in 2019 because it's in a different system, that's all.
Okay, so would you take a stab at that new clarification language, and then that would be great. Thank you.
Sure.
And thank you for having us in.
Thanks for doing this.
Madam Chair,
Representative Morris.
would that cause us to have to hear from other interested parties?
Again,
Yeah, to see if that language would be.
that's a good question. I mean, with the knowledge that our judiciary committee has to review this as well, I would feel more, I mean, surely they'll circle back to the judicial branch and other law enforcement related. So I guess it's up to you all, but I would be okay sending it on, I think. Once we see it. See if we have further questions and how it sits with all of us. So we appreciate that. Thank you.
Thank you.
Next up, we have another Fish and Wildlife. Okay. Is Luke joining us by Zoom? Do we need a break? We've been going for an hour.
Yeah. Hour 10.
Okay. 5-minute break. Please be prompt.